Well, good afternoon, everybody, and thank you to Susan and Brianna at Lupus LA for putting this live stream together. My name is Alan Kassan. I am a lawyer, a partner at the law firm of Kantor Kantor, and I have a lot to cover today to talk to you about disability benefits and how they might impact your lives. And so let's get right to it. I'll start by telling you a little bit about my firm and myself. Kantor Kantor was established about 16 years ago. We started with a small group of insurance lawyers, and we were all dedicated to the idea of helping people battle insurance companies. Battle the insurance companies that have denied their insurance claims, mainly related to life, disability, and major health insurance benefits. We grew from about 6 lawyers to now 20. Originally, our offices were just in Los Angeles. Now we have an office in Northern California, an office in San Diego, and recently an office in Seattle, Washington, handling the Pacific Northwest. But we also litigate throughout the United States because a lot of the work we do is in the federal courts, and the federal court law is consistent throughout the country, so we're able to practice nationwide. Personally, I've been a lawyer for over 35 years. I've been with Kantor Kantor since we started to help build the firm. We've helped probably thousands of people with disability and other health-related claims against insurance companies. And we're proud of the work we do. We've established an excellent reputation in the community. We get referrals from lots of lawyers around the country. We even get referrals from judges and other professionals because there are not many lawyers who do what we do and not many that do it well. So I talked a little bit about the practice areas. Let me just explain a little bit more. The area that we practice in is a very specialized and niche area. There are not a lot of lawyers that practice in this area, so oftentimes people have a hard time finding a lawyer that has experience in some of the issues and matters that we tackle, and I'll talk more about that also. I also want to say that I know, and I'm sympathetic because I hear it from clients all the time, that it's not always easy to find a lawyer that you can ask questions to comfortably. I know lawyers can be intimidating. I personally don't think I'm an intimidating lawyer, but I know that sometimes people are unsure of what questions to ask or how the process works. People are also often unsure and maybe even worried about the cost of retaining a lawyer. Our firm has a policy that we will talk to anybody and try to give input and listen to what your story is, and we won't charge for that. We'll even look at documents and try to give advice. Many, many times we're able to give people direction or suggestions as to how they might proceed, and they don't even have to retain us. And we're happy to do that because at the end of the day, I think the objective of everybody in my firm is to not let the insurance companies win. The insurance companies have a lot of money, a lot of resources. People with disabilities don't. The insurance companies know that, and unfortunately they take advantage of it, so we're here to do everything that we can to help. And also, the way that we charge for our services is we don't charge an hourly fee. Some of you may have heard the term contingency fee. We charge a percentage of the benefits that we may recover for our clients. And that means that if you don't win or we don't recover anything, you don't pay the lawyers. And that can even extend to costs. Sometimes it's expensive to fight insurance companies, and we will usually advance those costs without seeking income or payment from our clients. And then when we win and recover, we'll deduct those costs from the recovery. So it's not hard, it's not expensive, it's not scary. And I honestly, I should be fair, and I don't just speak for our firm. There are other firms, not many, but there are other firms and very capable lawyers around the state of California and even around the country, and we know many of them. and they're capable. So I usually recommend that people looking for a lawyer talk to at least 2 lawyers and get a sense of, it's not always just competence and knowledge. It's oftentimes going to be who you feel comfortable with and who you feel that you have a rapport with and understands your issues. So just want to get that out of the way. Today what I'm going to talk about is disability insurance. And before I launch into the whole explanation of what disability insurance is, I want to tell you what disability insurance isn't with respect to the work that we do. When somebody suffers from a disability, there are many avenues for potential relief. You can apply to the state for state disability insurance. Most of you probably know that when you have a job and you have your payroll deductions, a small amount of that deduction every month goes to pay the state for a disability benefit. And if somebody becomes disabled, it's pretty easy to obtain state disability benefits by simply filing a claim and offering some support from a doctor. And that benefit is, I don't know exactly, but it's about 60% of your weekly salary. And usually those benefits will be paid for up to a year. We don't get involved in those kinds of things, those kinds of claims. They're fairly automatic and straightforward, as I said, as long as you have doctor support. So most people don't have problems or issues with state disability, also referred to as SDI. The other big one, of course, is Social Security disability, and I think everybody knows about Social Security disability. Again, most of us pay into the Social Security system, and in addition to Social Security retirement benefits, the government also provides a disability benefit, so that if unfortunately you become disabled before it's time to retire, you can tap into those benefits and get close to, if not equal to, what your retirement benefit would be as soon as you become disabled. Little more difficult. The government has clamped down on Social Security disability benefits, but again, the process is straightforward. The forms are online. All the information is online. You fill out the forms, you send in the support, and your claim there is either accepted or denied. But again, we don't deal with Social Security disability insurance. Many of our clients have claims with Social Security, and there's a huge amount of overlap. But we refer those matters to Social Security lawyers that we work closely with, because they're the experts in that area, and we work together to hopefully obtain positive results for Social Security disability. There's also workers' comp. Most people have also heard of workers' comp. You become injured on the job, you can make a claim against the work comp carrier, the employer's insurance carrier, and that's a whole nother process, which involves another whole niche in the practice of law, workers' compensation lawyers. And again, we don't do that, but we do work closely with a lot of workers' compensation lawyers, so we can often refer people who inquire or our clients to any of the lawyers that deal with those things. So what we do is we deal with the disability insurance, both long-term and short-term disability insurance, that many, many employers provide through the course of employment. Sometimes the employers will provide that insurance at no cost, and oftentimes you may not even know about it. So first note, if you're taking notes, to check into is whether or not your employer has provided you, or there is the provision of short-term and long-term disability benefits at your place of employment. Oftentimes, employers might supply a small benefit, and if you want to increase that benefit, you would have to then contribute to the premium, and that would be a deduction from your paycheck. Most people in the United States get their disability and health insurance and even life insurance through their place of employment, but there are many people who either want to supplement that disability insurance or who don't have the benefit of disability insurance through their employer. And they can go out and directly buy disability insurance products from an insurance company. So those would be individual policies compared to what we'll call an employment disability policy. We handle all of those kinds of insurance policies. So not government provided benefits, but benefits that are offered through an insurance company. Or what's also true is really large employers sometimes will self-insure. So rather than going to a MetLife or a Unum or a Cigna or somebody, they will establish a program where all the premiums will be paid, put into a fund, and they'll self-insure. Most likely they'll have an insurance company that will administer it, but all of the benefits are paid out of an employer managed fund for the benefits of the employees. We handle all of that too. So another important thing for people to keep in mind, and it's something that very few people realize until they're thrust into the world of having to deal with an insurance company and a disability claim, is that claims can be governed by state law or they can be governed by federal law. And it's fairly easy to distinguish between the two, because if your claim is provided through your employer, it's governed by a law which goes by the acronym of ERISA, E-R-I-S-A. And ERISA stands for the Employee Retirement Income Security Act, a huge convoluted scheme of law that was enacted in 1974. And the purpose was to protect employee benefits. I don't think when they enacted it, they necessarily had health and disability insurance benefits in mind, but the law has evolved now that all of those benefits are wrapped into the umbrella of ERISA. And the good and bad about ERISA is that it is a somewhat more streamlined procedure. The bad is that it's in federal court, and the benefits are very limited. Under the law of ERISA, the only benefits that an insured can enjoy or recover if an insurance company acts badly and denies the benefits is to recover those benefits. Whereas in state law, if an individual went and purchased a disability product by themselves, not through their employer, the disability claim would be governed under state law. And in California, we live in a very consumer-friendly state, and the law is much more generous and kind to insureds than the ERISA law is. So in California and many other states, if an insurance company acts badly or in bad faith or is not fair or reasonable in the administration of your claim, you can sue the insurance company not just for the benefits that you seek, but also for emotional distress that they may cause, potentially punitive damages, attorney's fees, other out-of-pocket costs. Of course, you have to prove those damages, but they're available. And under state law, you also have the right to a jury trial. Under federal law, there is no jury trial. There are no other benefits. Sometimes attorney's fees can be recovered, but usually it's just the benefits. So what I always explain to my clients or people who call is that because of the way the law has been crafted and evolved, the insurance companies really almost have an incentive to deny claims because there are no repercussions. There are no adverse consequences other than possibly having to engage in litigation and maybe having to pay the plaintiff insured's attorney's fees. But that's not the norm. You know, there's a small percentage of cases that actually make their way to litigation or make their way to a trial. And the insurance companies know that, and they play those numbers, and they know the odds are that it's slim. So if out of 10 or 20% of the claims they have to fight, that means there's 80 or 90% of the claims that they win, that they deny, and they benefit from. I also like to say insurance companies are really good at two things. They're really good at selling insurance product. You see their ads, there's scare tactics. There's also security issues. People want to feel comfortable and protected financially. It's an understandable desire. So they're great at tapping into those things and selling the product. But then on the flip side, they have a whole nother department that's also really good at denying the payment of claims. So you just need to be cognizant of that when you're not only when you're challenged or faced with the problem or the burden of making a claim. But if you have the opportunity to buy your insurance, you should give that some thought. Individual insurance, you should give that some thought as well. Okay, I'm going to begin by kind of giving you an overview of some of the things that are typically part and parcel of a disability policy, and then I'm going to talk about submitting a claim and then fighting a claim that's been denied. But before I do that, I just want to also add something I meant to mention earlier. Because of what we do, and because we've been doing it for so long, we have helped people with almost every disabling condition you can think of. And that includes a lot of autoimmune disorders because they're rather common and disabling. And that would include lupus, of course, Graves' disease, rheumatoid arthritis, celiac disease, type 1 diabetes, many other things. And then beyond that, Parkinson's and multiple sclerosis. We have a lot of migraine headache issues. We have a lot of degenerative back condition issues. It really runs the gamut. So we're pretty familiar with the issues that disabled individuals encounter. We're sympathetic, and we fight hard to help push back on insurance company denials. So let's talk a little bit about insurance product basics. A disability policy provides some element of comfort and I guess relief from the financial difficulties that are cast upon somebody who can no longer work. So they're commonly thought of or referred to as income replacement benefits. I talked about having to pay the premiums and how the premiums are paid. The policies will also almost universally define what it means to be disabled, and usually they are categorized by two sorts of definitions of disability. They will pay benefits if somebody is disabled from their own occupation, the occupation that person was in at the time they became disabled, and they'll do that for some period of time, usually 24 months, sometimes 12, sometimes longer than 24. But they'll pay benefits so long as you can prove to their satisfaction that you can't perform the material duties of your occupation. But then after 24 months, the definition will change, and you will have to prove to the insurance company that you can't engage in the material duties of any occupation which you might be suited to by way of your education and your training and your experience. That can be a more difficult threshold to cross because if you have a decent education and you're young, it's likely that there may be other things you could do, again, really dependent entirely upon the nature of your disability. Now, that's probably a lot more true for people with physical disabilities such as cervical neck problems or degenerative back problems that can't do any kind of work that they've been trained for. But people that have pain and cognitive impairment and fatigue and gastrointestinal disorders, dermatological disorders, those things are a little bit more amorphous and hard to pin down with objective diagnostic criteria. So the insurance companies will frequently say these are self-reported symptoms. There's no evidence that they're disabling. So these are the kinds of things you should just be aware of as you think about disability insurance. And by the way, a lot of this also applies to the other types of disability benefits that I mentioned early on, the Social Security, the state disability, the workers' comp. So you have the definition of disability, and you should check. Sometimes policies are generous. If an employer has negotiated a good policy, sometimes policies will not have an own occupation, which converts to an any occupation definition of disability. They will insure you so long as you can't engage in the duties of your own occupation. And that's common for executives and professionals and people that are in maybe more unusual types of positions. So something that you should be aware of before you really even think about making a claim or challenging a claim. Benefits will also have a waiting period. Policies call that an elimination period. So you will have to remain disabled for, it's usually about 180 days, 6 months. Sometimes it's 3 months, sometimes it's 12 months. But before benefits will actually be paid, you have to remain disabled for that specified period of time. Benefits policies will also define how long benefits will be paid. And again, usually benefits are paid until age 65. Many policies now will pay benefits until normal retirement age, according to Social Security, and that's now extending beyond 65, 66, 67, 68. So that's how long benefits will continue, again, so long as you can prove on a regular periodic basis that you continue to remain disabled. Benefit amounts under disability policies range. The average is probably 60% of your pre-disability income. Could be less, could be more. Again, something to be aware of before you consider making a disability claim or understanding the relative risks and rewards of making a claim. Disability policies also have exclusions, and this is something that comes as a surprise to many people. In fact, most people believe simplistically that if their doctor says they're disabled and writes a note to take them off work, that the insurance company is going to automatically pay them, and that is can be a critical fatal mistake, because if you proceed on that basis without fully understanding how the process works, you're undoubtedly going to make mistakes and fall victim to pitfalls. So it's really imperative that you understand what kind of disability coverage you have and what is covered and what might not be covered, and the kind of things that aren't covered or that might be limited would be, for example, mental nervous disorders is how they're kind of summarized or phrased in disability policies. Oftentimes, disability policies will limit benefits for anything having to do with any kind of a mental disorder, depression, anxiety, paranoia, sometimes even bipolar, to 24 months. So when somebody is doing their financial calculations about how they're going to pay their rent and buy food over the next many months or years if they're disabled, and it's not safe to just assume that the disability policy is going to step in and handle all of that and take care of you for up until age 65 or retirement age. So you need to be careful and aware of these kinds of restrictions or limitations, exclusions. There's also what's known as a pre-existing exclusion, pre-existing condition exclusion in disability policies, and that means, it's pretty self-explanatory, that means that if you have an ailment, a disease that maybe didn't absolutely disable you before, and then you obtain disability insurance and make a claim within 12 months of that disability insurance becoming effective, if you were treated or diagnosed or seen by a doctor within a certain period of time prior to the insurance becoming effective, usually it's 3 months, could be 6 months or 12 months, then you're not entitled to disability benefits. So what they're trying to accomplish here is they're trying to prevent people from getting a job or going and knowing that they're sick or that they may not be able to work, somehow going out and getting disability coverage, immediately making a claim, and then essentially taking advantage of the insurance company when they knew they weren't disabled. So in this case, it's probably fair to the insurance company, but what's also true is the insurance companies abuse this provision repeatedly. They will expand the scope of what might be included in these pre-existing condition limitations. So I should say this now, and it applies to almost everything I'm going to say. When an insurance company says no, don't believe them, don't be intimidated, and don't give up, because they're almost always going to say no, but the more you push, the more likely it is that you're going to be able to push back and realize some kind of a benefit. Okay, and finally, with respect to the disability policy, it's also really important to know that and this is something that comes as a surprise to some people, just because you've been diagnosed with a disease or an ailment, a sickness, that doesn't automatically mean that you're entitled to disability benefits. And again, that kind of makes sense because a lot of people are diagnosed at a very early stage. The diagnosis may be conditional, it may be tentative. So what insurance companies look at is not what your doctor has diagnosed you with, but what your doctor says you can or can't do. And the buzzwords there are restrictions and limitations. So, and I laugh, but it's not funny. Oftentimes doctors will say, my client can't work because she has lupus, or my client can't work because he's been diagnosed with rheumatoid arthritis. But the insurance company is going to immediately push back and say, yeah, but what does that mean? Exactly what can't this individual do from a functional standpoint in a work environment? Can they sit? Can they stand? Can they analyze? Can they talk on the phone? What can or can't they do that marks the points of disability that actually constitutes a disability as defined within the insurance policy? So always think in terms of restrictions and limitations when you talk to your doctor and when you communicate with your insurance company, because that's what they're looking at. I think I covered I covered the distinction between ERISA and non-ERISA. So let's talk a little bit about the ERISA framework a little more, because, as I said, it is the most common type of disability or life or health insurance claim that we see. Employer-provided insurance is ubiquitous because it's less expensive. Group insurance typically is less expensive than individual insurance, and so it's easier for employers to obtain it, and it represents a fairly attractive benefit to a lot of employees to be able to get a job and be provided with health insurance and disability insurance and life insurance. So employers enjoy providing those benefits if it's affordable. And insurance companies like selling the product because even though they sell it at a lower rate, they know that they are somewhat insulated from damage claims because those claims are governed by or come under the umbrella of ERISA. ERISA has a somewhat cumbersome procedure for people to follow in order to comply with the law and pursue their benefits. And one of the biggest issues that comes up all the time is that under ERISA, if an insurance company denies your claim, you have 180 days to appeal that claim in writing. And if you don't, you lose the right not only to appeal, but you lose the right to file a lawsuit in court. Happens all the time, and unfortunately we see too many people that come to us too late. They're not sure what to do when they get a denial from an insurance company. They can't find a lawyer that can help them. Sometimes they're hospitalized or depressed or whatever the issue may be. Time passes and they come to us when it's too late and we have to deliver bad news. So under ERISA, that's kind of one of those pitfalls that the insurance company benefits from. You have to appeal, and you have to appeal in writing. As I said, there's no jury trials. ERISA policies also include offsets for other benefits, which individual policies might not. So if you file a claim for ERISA disability benefits and you're awarded those benefits, you're also going to be required to file a claim under the Social Security guise. And if you are awarded Social Security benefits, the ERISA insurance company disability benefit provider is going to be entitled to offset those benefits. So for sake of simple example, let's just say you are awarded $4,000 a month in disability benefits and you're awarded $2,000 a month from Social Security. Your net benefit won't be $6,000 a month. It'll still be the $4,000 a month because the insurance company will only have to pay you that $4,000 minus what you're getting from Social Security. So again, another shocking piece of news that we often have to deliver to our clients or people who call. Okay, so let's talk about submitting a claim. Submitting a claim is pretty simple, straightforward. It's most often done by calling the insurance company and indicating that you believe you might be entitled to a disability benefit. Nowadays, many times you can go online and get information about submitting a claim from larger employers. You can even download forms to do that. If you call, the insurance company will send you a package of forms and applications and release documents and things that they need you to execute to proceed. They will probably also want to conduct an early interview with you on the phone. And I say this because these are the kinds of things you should think about before you actually initiate the claim process. You should be prepared to tell your story, and you should be prepared to be able to supply the type of medical evidence that you will need to support your claim and establish your entitlement to benefits. And that means a lot of things. That means that it's probably imperative that before you contact the insurance company, you read your disability policy, and if you don't have it, that you request a copy of it and read through it, so at least you know a lot more about the landscape and the things that you might need to be concerned about when you do ultimately make a claim. And I always recommend, when it's possible, that people talk to their doctors about it first. If you feel that your disease, your ailments are becoming a greater and greater burden, and you can't be effective at work, or you're fearful that you're making mistakes, or that your employer is not going to be happy with your performance, or if you feel, which is also very common, that work is causing a lot of stress, which is exacerbating your physical condition or your mental condition, that's the time to not just make a knee-jerk disability claim, but to start thinking about how to make a claim. And as I said, understand your policy, your rights, and talk to your doctor or doctors about the process and get a sense of what they think. What's also very true and rather unfortunate is that people just assume that their doctors will help them and support them. And so they initiate the process, and the insurance company submits forms for the doctor to fill out. They will make a formal request for all the doctor's medical records. They will probably at some point even have one of their doctor consultants consult with your doctor. And unfortunately, oftentimes, particularly when doctors don't have a heads up or haven't engaged the client and understand the client's situation, they won't be really good advocates for disability. And they may tend to waver or equivocate when asked questions. And then at a later date, when you do have that conversation and ask them to support you, and they say, oh, by all means, now, I'll help you, the insurance company is going to hear a different story than what they heard originally, and then your doctor may have some credibility issues. So again, the point, I'm probably belaboring it, but the important thing is to prepare and contemplate the things that you may encounter when you're going to be engaged in making a claim. Another really important thing to consider is that you should never communicate with an insurance company solely in writing, solely on the phone rather. It should always be in writing. It should also be in a trackable format. You should Email will work if you can get an email from the insurance company. Same thing with fax. But if not, you need to go to the trouble of, like we used to in the old days, write an actual letter and put it in snail mail and send it to them. But it's critical that everything be documented. And I can't emphasize this enough, because you will hear things from insurance representatives or even see notes in insurance company log files where they will characterize what a conversation was with an insured that really bears no resemblance to what happened or what the insured said. So again, I don't want to overemphasize, but it is important that everything be in writing and that you keep copies and document your steps. Okay. One other important thing to be aware of is that once you submit a claim, the insurance company will automatically fall into this mindset that you might be trying to take advantage of them. And they will launch a predetermined set of steps to investigate who you are and what you've done and what you truly may or may not be capable of. And the two big tools that they use are social media investigations, and they hire companies that will dig really deep in social media, going back as far as they can to find anything they believe is inconsistent with the claims that you make about disability. And I think we all can agree that people who are disabled don't usually go onto social media and complain about how terrible their lives are. Social media is more commonly an avenue where you try to think positive and you share the positive things with your friends and your family or other people who are connected to your social media accounts, Instagram, for example. And you need to be careful, because you may not be portraying your true self, or how truly you may be suffering on a day-to-day basis. You may have had, you may be suffering day to day, but you have the occasion to go take a hike or go to a party with friends, and everything looks great and you're enjoying yourself, and you post that on social media. You don't post on social media the fact that for the next 3 days you were in bed, or you were in pain, or you were on medication, or you were at the doctor. So social media is important to be careful with, and also be aware that if they really suspect, particularly if they find things on social media that they think are inconsistent with your reports, they will order surveillance, and that's legal, even though people think it isn't. But they will hire an investigator to follow you and film you for a day or for several days, and report back to the insurance company. So scary, but as long as you're aware of it, it's a lot less of a problem. All right, I want to talk about supporting your claim, and I know I'm probably talking too much, and I apologize. Brianna, are you there? Am I okay?
Yeah, you're doing great. Thanks for all the info, Alan.
Okay, okay. So I've touched on this a little bit, but I think it's important to go through it a little bit more. How do you support your claim? How do you increase the chances that the insurance company is not going to deny you? And I think a lot of it is common sense. Some of it maybe not so, but let me go through some of these things. And I have a checklist, so forgive my eyes from wandering here. But first of all, it's important that when the insurance company sends you documents, that you return those documents in a timely manner. So again, kind of a no-brainer. You're going to want to carefully formulate a statement that you may want to add or supply to the insurance company that shares your issues, your day-to-day activities, your frustrations, your pains, your limitations. And I can't remember if I said this already, but the insurance company claim forms will provide little boxes. They'll have little check marks, and then they'll ask you a question that could probably be answered with volumes, and they'll give you this much space to answer it. Do not ever be constrained by an insurance company claim form, and I cannot emphasize this enough either. Too many people try to cram an explanation of their problems into a little box, and it's either illegible or it's certainly not complete, and it just doesn't start the process out right. If you need to, just say "see attached" and add as many pages as you feel necessary to explain your situation and your claims. Now, be careful. Don't go overboard and don't start going into too much detail that you don't have actual medical and factual support for. But it's certainly okay to explain to them how you are suffering, and I think that's appropriate. You're going to have to go to your doctor and get your doctor to sign a form. And as I said before, it's really valuable and important to try to have a conversation with your doctor before just showing up and say, oh, by the way, will you sign this form? I find that doctors are far more receptive, empathetic, and act as far greater or better advocates if they have already engaged in a dialogue with their patient, and so that they feel that they're part of the process in supporting a disability, rather than the patient who went on the internet and researched things and came into their office and said, hey, the internet says that I can get disability benefits, sign here. Doctors don't like that. So your doctor's your partner. Engage your doctor in the process. If you have an employer who is sympathetic, or a supervisor, it'll be helpful to get a statement from that person. Same thing with friends and family members. Even though the insurance company will say, well, that's self-serving and those people are biased, it doesn't hurt. It doesn't hurt. And as lawyers, even though the insurance company discounts them, we use those statements to draft a very compelling story of the day-to-day suffering that our clients experience. And we've seen time and time again that judges pick up on those stories and recite them in their opinions sometimes, even though the insurance companies completely discounted them. So valuable stuff. A detailed job description is important. The insurance company is entitled to know, and it's important for you to share with them exactly what your job requires. I mean, to say that I'm an administrative assistant, or I'm a clerical worker, or even that I'm a lawyer, or a dental hygienist, it's not enough. You have to explain what you do and why you can't do what you were required to do given the issues related to your disability. Also, if you've been awarded state disability benefits or Social Security or work comp, scour those files, because more than likely there's going to be statements from doctors or judges or attorneys or whatever that support your disability, that would help support your long-term disability from an insurance standpoint. Let's see. One other thing to consider, back to your doctor as a partner. Human nature is to put your best foot forward. And when you walk into your doctor, one of the first questions that doctors always ask is, how are you feeling? And one of the first things patients almost always say is, I'm doing okay, even though you're really not doing okay. But it's the social graces, it's the optimist in us all. And insurance companies seize on those statements. So, from a small talk standpoint, it's okay to say, yeah, doc, I'm doing okay, but here's what the real problems are. And then to elaborate on what okay means. I'm okay today relative to how I was, in bed for the last week, but I'm really not okay. And on that same score, it's important to and I don't know exactly how to tell you to do this, but it's important to know whether or not your doctor is documenting what you're saying and reporting in his or her notes the things that you're saying. So I think if you speak slowly and you emphasize things and you ask the doctors questions, they're going to be much more likely to make notes. So keep that in mind, because ultimately those notes are going to be what the insurance company representatives scour, and they're going to look for any little thing in those notes that might be inconsistent with what you've said, or even with what the doctor is saying about your restrictions and limitations at a later date. And doctors, by the way, as do we all, forget what they may have said before. So the more able you are to help the discussion begin early and help the discussion be documented with your doctor, the better off you're going to be. Let me talk about some pitfalls, because this is really important, and it's where people fall into these traps all the time, and it's a challenge for lawyers to dig them out of these holes. So the first I said was dealing with the insurance company or communicating with them verbally. It's okay to do it, but make sure everything is backed up in writing. Critical. With regard to medical, I think actually I kind of stepped ahead of my notes here, and you want to make sure that you have this dialogue with your doctor and that the doctor's aware of all your issues. When you speak to your doctor and when you communicate with your insurance company, it's not uncommon that people naturally use superlatives, and they'll use the term "I'm always tired," or "I'm always in pain," or "I can never do this," or "I can never do that." And I think our sense of time is compacted when we're trying to explain what we're suffering from. Never might not mean never in the literal sense. It might be never. It might mean never in the last month, or the last week. So it's important not to speak in those terms or write in those terms. You have to be realistic because your credibility is at issue, and you don't want the insurance company to have any ammunition at all that they can use to try to impeach your credibility, challenge your credibility. And I know that's a high bar, and that might scare people because we all say things that we might regret or that might come back later to haunt us. So don't worry about it too much, but just because a lot of we can explain, but be aware of it. You want to tell a story, but you want the story to be accurate, and you want it to be compelling, and you don't want there to be things that a judge or even an insurance company might be able to poke at and say, well, yeah, the story sounds compelling, but look at this. Look what they said, back then, or look at what our surveillance showed, or whatever the case may be. So be honest, be detailed, and be careful. I talked about social media already. That's a big one. You always have to be cognizant, and I'm not a big social media person, but I know that friends of my friends of other friends serve as tunnels into your social media accounts. So if you don't want people seeing your social media accounts, you need to make sure you have the appropriate security set. All right, what happens when your claim is denied? Big question, and that's usually when people come to see a lawyer, or at least try to find a lawyer. In Erisa, when your claim is denied, they will send you a letter, and the letter will explain what they reviewed. It'll explain what your policy provides, and it'll explain that we've denied your claim and you have the right to appeal. As I said, usually that's about 180 days. Whatever it is, do not miss it. For any of you out there who currently are dealing with these issues, there is a stay of some of those deadlines right now. So because of the pandemic, the insurance companies are compelled to allow more time, but typically it's 180 days. Sometimes it's 60 or 90 days. With a lot of health claims and life insurance claims, it can be 60 days. So be careful. If there's a deadline in a letter you get from an insurance company, don't ignore it. That's probably the one of the most important messages I can give you today. But when you get the claim file, the denial letter, you should also immediately request a copy of your claim file, because you will or may have your medical records, and you may have the documents and the letters and the statements from friends or family that you sent in, but you won't have all of the things the insurance company has. You won't have the surveillance records. You won't have emails between the insurance company representatives and their doctors. You won't have telephone log notes. There's a lot of things that get generated by an insurance company when an individual makes a claim, and you want to see that. You want to know what they know, otherwise you're at a disadvantage. So one knee-jerk reaction should be to immediately request the claim file. And we do this, of course. It's the first thing we do when we start helping a client. And people call us, and sometimes we just help them make that claim, that request on their own, and they don't even have to retain or engage us. It's not a complicated process, but it's an important one. If the case is not governed by Erisa, if it's an individual policy, or even sometimes group policies are excluded from Erisa, then the obligation to appeal may not exist. So again, it's important to know what you're dealing with before you make any assumptions or act inappropriately. if you decide to challenge the denial, which you should, I can't think of a reason why anybody would not challenge a denial unless the person was making a fraudulent claim and they got caught. But that rarely happens in my experience, at least that I see. The people that contact us usually have legitimate claims, and they're afraid to appeal. They don't know how to appeal. So I personally, and I think most of the lawyers in our firm, will explain the appeal process. We have some resources on our website. People sometimes want to do it on their own. I'll give some guidance, some suggestions, and it's not that hard if you're on top of all the issues and you're capable. Oftentimes, of course, your disability may not allow you either physically or cognitively to go through the stress and challenge of a denial, which would then be an appropriate time to retain a lawyer. But if you can do it, you can, and it's it's complicated, but it's not. It depends on your sophistication and comfort level. An appeal involves writing a letter, and then it basically rebutting the things that they've said in their denial. Insurance companies always make all kinds of false statements or erroneous statements in the denial letters. They mischaracterize what you've said. They mischaracterize what your doctors have said. And so it's incumbent upon you or your lawyer to go to work through those misstatements or falsehoods and correct them and rebut them. And that often involves talking with your treating physicians, maybe even engaging new physicians to get new independent opinions, and basically just pushing back and countering everything that the insurance company has alleged. We often see denial letters where somebody may have, lupus, for example, and an insurance company will retain a doctor in a specialty that is nowhere near related to the issues that a person with an autoimmune disease is suffering from. It could be a psychiatrist or an OBGYN or an ophthalmologist, and they won't specifically point out what kind of doctor they had review your records, but if you scrutinize the notes and you research it, you'll learn that, hey, it's not, since when can an OBGYN, or since when is an OBGYN the best doctor to opine on somebody who's suffering from lupus? And the answer is not often. Unless that person has another subspecialty that you weren't aware of. But these are the kinds of things that go on, and they do it because it's cheap, or they have these doctors on retainer or in their payroll, and these doctors support these denial letters at a rate of thousands a year. So you have to push back. So your appeal letter includes all these things. It's a rebuttal. It's clarifying existing medical evidence. It may be establishing new medical evidence. They may be challenging or making inaccurate statements about your occupation, about your occupational duties. They may misinterpret or mischaracterize what it is that you actually do at work, and they will refer to occupational guides. There's many guides in the world of vocational studies that explain or describe what job titles entail. There are job titles, and then there are explanations of what that job entails. But your job or your job title might not fit into that rubric or that norm that they find in their resources, or that their vocational consultant found in their resources. So if they elaborate in the denial letter and it's inconsistent with what your occupation was about, then you point it out. But if they don't elaborate, again, you need to look through the claim file and get a sense of whether or not they truly understand what your job was all about. And if you were able to provide a job description at the outset, and they just completely ignored that, well, again, that's a bad act on their part, and something that they're going to have to answer for later on. Okay, that covers the appeal, I think, for the most part. And finally, I guess the big question is going to be, okay, I've submitted my claim. I appealed either on my own or with a lawyer. Well, let's talk about appealing on your own. If you appealed on your own and the denial is upheld, you will either have notice in the letter that you have the right to appeal again, which is not as common, or they will tell you you've exhausted your ERISA administrative remedies, meaning you've exhausted that requirement to submit an appeal within 180 days. And once you exhaust your administrative remedies, you then are entitled to bring a lawsuit. Some people file lawsuits on their own. Most people seek out the help of a lawyer. And I recommend that you, even if you want to do it on your own, that you do consult with lawyers like us. And as I said, there are many other lawyers in California and throughout the country. I say many, and that's a relative term. There's nowhere near the number of lawyers that handle ERISA claims as those that might handle real estate or personal injury or dissolution or probate. A small fraction of those lawyers, the percentage or numbers of those lawyers engage in ERISA subspecialty. So, yeah, seek out a lawyer who you believe can help you. You can do some internet research. Look for somebody who has a demonstrated experience with these types of claims. Look for somebody that you can find some good referrals online or referrals from other lawyers or friends. You might even check State Bar for discipline. And consider whether or not those lawyers are willing to speak with you without charge, free consultations, and also consider how they propose to charge you if you do go forward and file a lawsuit. So those are important questions to ask. And you know what? I think I will not hesitate to say that it's a good idea to probably talk to at least two lawyers. You might find two lawyers that have similar qualifications or capabilities, and then it's going to be a matter of who do you feel most comfortable with? Who do you feel understands you, that you can communicate with, and that you believe will act as your most vigorous advocate? So that kind of completes my portion of the program. I don't know if anybody has any questions, Brianna, but I'm certainly willing to try to address some.
Yeah, I can jump in there. We do have some questions coming in, so we'll just, in wrapping up, if you have a second, we'll ask you a couple of them. The first one, someone said, how long should I be dealing with an insurance company before contacting a lawyer like you?
Well, I think that depends on where in the fight you are. If you're at the very initial stages, I would say that it's not necessary to communicate with a lawyer as long as you're documenting everything in writing. The better paper trail that you have when you come to a lawyer or when you challenge an insurance company, the better off you're going to be. So insurance companies will almost always send the claim documentation to initiate the claim, so that's not usually a problem. What's usually a problem is that you submit your claim and they don't respond. And fortunately, under ERISA, there are specific time regulations, time imposition regulations that impose the time limits on their responses. So, yeah, 45 days typically is the well, it's a little bit different for the claim, but if you don't get satisfaction or you feel that you're getting the runaround or being stonewalled within a month or two of trying to get answers from an insurance company, not a bad idea to reach out and talk to a lawyer, and the lawyer will probably give you a sense of whether it's appropriate to continue dialogue with a lawyer or whether there are ways that you might better push back on your own.
Okay, great. Thank you so much. Can you explain the difference between short and long-term disability insurance for people who suffer from a chronic disease like lupus? Is that something that you can?
Yeah. Sorry, I meant to cover that earlier. So most employers have a short-term disability benefit program. Not as many employers have long-term disability benefit programs, but I think it's fair to say that most employers provide both. Short-term disability is, as its name suggests, provided for a much shorter term. Usually it's 6 months. Sometimes it can be 12 months. But all of the things I talked about with respect to making the claim, proving the claim, establishing the claim, in terms of long-term disability, similarly apply to short-term disability. So the difference really is going to be the duration of the benefit, sometimes the amount. Oftentimes the short-term disability benefit amount might be larger than your long-term disability benefit amount. But the distinction is it's 6 months, sometimes 12 months, and then your claim would roll into a long-term disability claim. And incidentally, some employers, fewer and fewer these days, but some employer plans require that you be awarded short-term disability benefits in order to qualify or be eligible for long-term disability benefits. So I should have said this, and I apologize, but when you make inquiry about your benefits, inquire about both short-term and long-term disability.
Got it. Thank you. That's so helpful. I'll just wrap up with one or two more questions here that are case specific. So one was this patient reached out and said, my enamel and bones around my teeth are now being eaten away because of my lupus. My insurance isn't covering my dental work. I'm using care credit and doing everything I can to manage my lupus. Is this something I can appeal?
Yeah, this is not uncommon, and it's a difficult challenge because here we're talking about a health insurance claim or a health-related insurance claim. If it's a dental insurance issue, your disability benefit's not going to cover that. Your health insurance coverage may or may not cover it, but even if there is some coverage for dental issues, the insurance company may argue that that is a cosmetic issue and not a medically necessary issue. And, it would probably take far too long to get into the details about this. But short story is you should definitely push back. You should definitely fight it. You should definitely get your doctors to try to advocate on your behalf, because sometimes, especially for smaller claims, I think I see here it's $3,500. Insurance companies may not want to fight it, and if they have a vigorous support from doctors, they may just roll over and pay. The other thing you can do is you can, and I don't know where this person lives, but small claims court can often be a good remedy for claims like this, because in California the limit for small claims court now I think is $10,000, and insurance companies don't want to have to deal with small claims courts. They have to send a representative. It's a pain in the rear end. So something to consider.
Wow, that's really helpful. Thanks, Alan. Wouldn't have thought about that. Thank you so much for taking the time to answer these questions and to share all of your expertise with us today. This is incredibly helpful and valuable. For anyone else that had questions around this topic or that is coming in late and have some questions, feel free to shoot them to us in the comments or send us a direct message, and we'll be following up with a blog post with some additional answers around Alan's expertise. So thank you so much, Alan. We'll put the links to learn more about you and about Kantor Kantor in the post, so people will be able to take a look. And we're just really grateful to have had you today. Thank you. Thank
you. It's my pleasure. I apologize for going a little bit long. As I said, there's a lot to say, but I'm always here to help, and I don't want to discourage anybody from reaching out if they have questions after this. You can reach us with the information I think that Brianna is going to share with you. So thank you, everybody, and I hope I helped, and good luck. Stay healthy.
Thanks, Alan.
Okay. Bye-bye.